All right. It is awesome to see so many people in the meeting. I think we're over 100 and we'll have a ton more, but super happy to kick this thing off. Also really awesome to see everybody's location being posted in the chat. I'm Kevin Kleiman, the president of the Canadian business here at Employment Hero. Really appreciate everybody joining today. It's going to be a really important webinar. The legal impact of Ontario's Working for Workers Act, what employers must know. So everybody here is well aware Ontario's Working for Workers Act, including Acts 4 and 5, bring a ton of changes that will affect how all of us recruit, communicate with candidates, post jobs, follow up, and a ton more. And these updates aren't just legal obligations, they're big opportunities for organizations to build trust and transparency and fairness in hiring practice. Our speaker today is Justin Clory,
Hey,
one of the more awesome employment lawyers in our province and a partner from Navia Law. And over the next, so welcome, Justin. It's awesome to have you here. Really appreciate you, volunteering your time. Over the next hour or so, Justin's going to walk us through what's new under the Act. So salary disclosures, AI usage, removal of the Canadian experience requirement, and a ton of other fun stuff. What's upcoming in terms of compliance deadlines, what we can be doing right now to get ahead of all the surprises. And if you have any questions, please put them in the chat. We have somebody on the team who's monitoring it, and we're going to pull those out and make sure they try to get answered at the end of the hour. And without further ado, I'm pleased to introduce Justin. Justin, over to you, and I'll toss you the spotlight.
Thanks, Kevin. Thanks, everybody, for joining us. It's good to see that we've got people from all across the country, even some people I'm seeing in the States, as it looks like they're helping their companies manage their Canadian workforce. So thanks for joining us, everybody. Always happy to be here. It's a favorite part of my job is giving these webinars. I always just have to start with a little disclosure that this is, of course, legal information, and you should always consult a lawyer for specific advice on your situation. Right, and as Kevin mentioned, we're really going to focus on the changes that are coming into place in Ontario, but as Employment Hero assists businesses across the country, so does my firm. I've sprinkled in little tidbits from the rest of the country because some provinces are a little bit further ahead on the changes than Ontario is. So we'll cover focus primarily Ontario, but we'll cover other parts. So some of the things we're going to speak about are some salary ranges, changes to work experience in postings, AI disclosure, disclosure of the vacancy type, communications that are now going to be required in Ontario, some changes to records in Ontario, and then also we'll talk briefly, and I'll give a little information about some changes in Ontario that require offers and some information as someone starts their position to be in writing, right? Which is something that I'd always recommend as a lawyer. So I think with that, we'll dive into changes to the hiring process. So I've broken this up into two pieces. First, changes to the hiring process, and a little bit more about post-interview there. So the first and perhaps the biggest and most important topic that I'm sure brings everyone here is salary range disclosures. Right, so this is a trend we're seeing really globally all over the world. There's lots of American states that see it. I see it all the time, coming across all those job ads on LinkedIn with salary disclosures and things in them. Right, so it's really on the front. So if you're not in one of the provinces that are the proposed or the current requirements that I have there on the sheet, I'd highly encourage you to really get ready, because I'm sure at some point requirements to salary disclosures will really evolve and become the norm in every province here in Canada. And sometimes that even naturally happens by default once Ontario and BC enter into something, because those provinces make up more than half of the country. So really, in all reality, that a lot of businesses then begin to do that. And if you're not, it may also make it more difficult for you to attract good candidates because they'll naturally go to the positions that have the disclosure because they know that there's an alignment there on value and what each side will be doing in consideration, right? So as I spoke there before, majority of provinces have implemented this, and it's important to note that this is on public postings made by you or on your behalf. So it's important to consider that in Ontario and some of the other provinces, they've really shifted and put the liability for anything that happens with a recruiter onto the actual business itself that has hired the recruiter or the agent. So you used to be able to say, well, actually, the agent did all of the hiring. They were the one that didn't include a salary range. While this isn't part of this legislation, I'm just advising everyone to really make sure that your agents or anyone you're hiring do that. Double check them, make sure that you're vetting the posting and that you think it's being done correctly because it's a little bit ambiguous right now on where that liability would hit. And in all reality, I always say there's no one at the court's gatekeeping saying the liability sits here. So if anything goes wrong, you may be part of that litigation as well. And you want to be able to demonstrate with all of this that you've made efforts to comply there. But a court really will probably likely let an individual recover from either side. And then it's between you and the agent to decide really where the liability sits in further litigation. Sorry, my allergies have begun to hit for the fall. So this excludes just a general campaign where you're like, in your window, we're hiring, we've got a ton of positions, right? Help wanted signs. It's not included for internal postings in Ontario. And I believe this is the same in BC. I'm not as familiar with PEI, even though it's home. Don't really have any clients there in PEI. But I believe as well there it's not for internal postings. And that brings me to the asterisk at the bottom is that everyone should really consider the impact of this on their current employees. As you go to hire, they may see these postings in the salary ranges. So you're going to want to look back and consider as you're hiring how you're messaging that to your employees. So I would say you should really lean on your HR partners, anyone that Employment Hero offers as a partner, just to ensure that you're thinking about the impact for your current employees, because you'll need to be prepared to discuss that there. And then, yeah, some general requirements. It's really based on wages and things that are non-negotiable. So if you've got incentive plans that are like for every $5,000 you sell, you get 500 bucks, that's going to need to be in the band that Ontario requires. And that band in Ontario should not exceed $50,000. And this was put into place because, funny enough, there were some places in the world that have put these into place, and then businesses just started to do, we will pay you anywhere between $40,000 and $240,000, which is really not a great indication of the legislation and what salary would be paid. So there's that to consider, right? So it will exclude though totally discretionary bonuses, that really you may or may not pay. It excludes benefits or other costs. It's really targeted at the wage and anything that really directly is considered part of their wage. And yeah, so it's good to note that Ontario, you need a band. Some provinces will let you do a specific number or different things. Ontario has just chosen that it really should be a band. And if there are any limitations, within that band, you really want to make them abundantly clear, right? So I've seen it written really well in some job offers where they say, please feel free to apply if you think you meet some of these requirements. Just note that this band then may not reflect the salary that we would provide to you if you don't meet all of these requirements. Or on the flip side, If you are willing to pay more for someone, note that at the same, right? This band, if you are exceptionally qualified, can be raised, right? So, and that's the thing to note. BC was very explicit with that to say that um, the band is like for an information purpose. If you can really demonstrate why you went outside the band, then you're fine, right? But I think as part of this, this is why some of the record come into play, right? And so for Ontario, it's not required for postings over $200,000. And so while it may potentially not be required if the band ends over $200,000, if you're starting below $200,000, I'd probably say it's really good just to still use the band, even if you go a little over that range there. So that's salary ranges. I'll try and slow it down. Yeah, so then it comes to things to communicate to employees or not. Um, So I'll kind of start on the don't communicate side of things. So one of the biggest changes in Ontario was to be explicit in the legislation that says Canadian work experience required was no longer going to be permissible in job offers or postings or anything. We couldn't require that. And while that may be in the legislation, in all reality, most provinces in Canada, their human rights legislation actually prohibits discrimination based on like where you come from, immigration status, things like that. So in all reality, it really was already a violation of the law. It's just the Ontario government sticking that in there to be extra explicit. And of course, if you're in a regulated industry at all, right? Lawyers, for example, there is some grace there for that, right? Where it makes sense. But at the end of the day, it's going to be up to you as the employer to demonstrate why you would still need that as a requirement, right? Um, so, for lawyers, for example, maybe it's more like um, understanding and experience with Canadian laws would probably be the best way to target that there as an asset. Right? But I think the government is really just trying to help immigrants as they come to Canada land well. Um, so one thing I wanted to note also was there is a growing trend across most provinces to say that you really can't ask what someone was paid before. Um, BC, this is explicit. Ontario, PEI, it's explicit. So you really want to make sure that you're not asking previous salaries and things like that. And that's just to create a fair playing field. And I would also say that there's a growing trend um, across the world and across countries to really be prohibiting any sort of retribution if your employees are talking about their salaries or discussing their salaries amongst themselves, right? So similar to how you're going to message and prepare as you're doing salary disclosures and postings, you may want to prepare yourself and think about how you may message those discussions if someone finds out when they're in similar positions that they're being paid different salaries, right? So I think a lot of the time it's probably easily spoken about when you talk about experience, but still you're going to want to be prepared to message that so that the employee really understands it and then sees how they can grow into the salary that the other individual has, right? So you can always use it as a positive to say, well, actually, for the following reasons, they've got a higher salary and talk about growing into it, right? And spin it as a positive. So things you also must include in your postings in Ontario is this new or existing vacancy? And I think this is really to target all of the job postings you see out there that speak about how our business is growing. Come join us. We're on this trajectory. when in all reality, the position is really just to fill an existing vacancy, right? No one really wants to talk about that someone has left. But the government of Ontario has decided that that is really an important piece of information, right? So that's also something to include in your posting, but also to make sure that any of your recruiters or yourself are prepared to talk about that to candidates, right? We helped the individual move on to a new position within the organization, right? Or, the individual grew into this role and, had reached their limit of growth, and we supported them as they moved on to the next stage in their career, right? There are always positive ways to spin these. And then probably the biggest one, and while we've received some guidance in the regulations, and that is on the use of artificial intelligence. Um, so I'm encouraging people to be as honest and transparent in this process and in the use of artificial intelligence, and to think about how they're going to respond or message and give people paths if they worry that the artificial intelligence has screened them out for some reason. And with artificial intelligence, like I say, any tool at the end of the day, it's a tool, and courts are gonna likely stick the liability on yourself as the business and not the artificial intelligence tool if it screens people out for reasons that would violate the law, right? So one really easy way that comes to mind is if someone goes on maternity leave and they have, two 18-month gaps on the resume, right? And AI may, by default, say, oh, well, this person has all these gaps. They have a short term in the middle. Um, we're going to screen them out. And there, without knowing it, you've really screened someone out for prohibited grounds, right? Which was maternity leave. So you're going to want to also talk about how it's being used in the screening process, in the selection process, and then I would say provide a path, the similar to how you see in a lot of job postings when they talk about accommodations, right? If you have any concerns with the use of artificial intelligence or you require accommodations in this interview process, please reach out to the following, right? And that just shows that you're really being open and transparent and being prepared to assist people where need be. And that's, artificial intelligence really still makes a lot of mistakes, right? So I was talking to someone today about it, and they were like, it's still making a mistake 2/3 of the time, right? So, well, it's a really, really great tool, and I love using it in my legal work. It's really a tool, so we do need to be prepared for when it makes some mistakes there. Let's go on to required communications. So, I think we've all heard about the term no more ghosting. So Ontario is the first province to require you to provide communications to anyone that you've interviewed. Right? I think a lot of times businesses are having people spend a lot of time in the interview process, and they want to make sure that candidates receive like a full circle there, right? And they understand that the position has closed and been filled. Right? So, this is going to require some effort on anybody who's got a recruiter or any recruiters there, to really make sure that they're tracking when the last point of contact in an interview type setting is with each candidate. Because 45 days, like likely good, but if you're doing 2 or 3 weeks of interviews, you want to make sure you give yourself the appropriate amount of time to make your first offer. Maybe your first candidate doesn't accept it. You want to make sure that your second and third options are still really there and available, right? So otherwise you're going to run up against that 45-day window. So that's really the important practical thing to remember. And there's no guidance on what the communication needs to be, just to let them know that they weren't selected, and the position has been filled. So just keep that in mind. And then I'll talk for a few minutes about written offer details. So um, in Canada, we have both a common law legal system and then the legislative legal system where all of our employment acts sit. Um, if you don't actually have a written agreement with someone, the common law actually may be what applies to your situation, right? So in each province, the minimum standards legislations are exactly that. They are just the minimums. They are not the rule. They are just a base level of protection. So I think what catches a lot of employers by surprise and a lot of the small businesses that I work with is they're like, oh, well, I thought like legally it was 1 week per year and that's it. That's what's in the act. But that's really only the default there to make sure that employees get something. Um, and the common law, depending on the position, it'll look at a whole host of factors. The individual's age, their tenure, the job market, the position, and the sophistication of the work that they were doing, right? So the harder that a court views it for someone to find a new job, the more time they will give. And they will look at extraordinary circumstances, right? If they determine you wrongfully let someone go and they were pregnant and they've got, 6 months left on their term, they may say, I'm going to award them that 6 month period. It would have been really difficult for them to get a job, plus, a couple months, right? And I've seen some cases where that's happened when the individual has been with the company less than a year. So it's really important to make sure you have written offers. And so while the Ontario government is saying there's a set number of things you must communicate to someone when they begin a job, I always really advise that any offer and employment agreement should really be in writing. And if you're in a hurry and you need to get someone an offer, I always say make sure you make it in writing and then make sure there's some sort of sentence there that says, and this is contingent upon signing our standard form employment agreement. Otherwise, even a verbal offer at the end of an interview may then be considered the employment contract. And then you've got common law, right? So some of the things that Ontario is really requiring would all be normally part of a regular employment agreement. So I always say, hey, do a regular employment agreement. You can always say it's effective today. Your start date is in 3 weeks, right? But that'll at least protect you there to say this written agreement is what applies. And that's things like the legal name, contact info of the employer, the location of work, starting salary, pay period and pay day, and description of anticipated hours of work. And I'd say too, for everybody, an employment agreement is really a fundamental part of the relationship. And a lot of what goes into it, courts consider fundamental terms. So you're going to want to make sure that it's well worded and well written, and ideally you've gotten legal advice on it, because some of these then may make it difficult for you to adjust your business, right? If the agreement says you work 8 to 4, Monday to Friday, end of sentence, you likely have lost the right to ask the employee to stay till 4:30 one day, right? And it would be hard to justify letting them go for that, right? So there's all these kind of little details there that go into this. And I threw a lot at everybody there in 25 minutes, but a lot of these changes, are really tiny. But what I thought I would do is I've written up a little bit of a sample job offer, and I thought we'd run through some poll questions, and then I'll kind of discuss about this, right? So I've written up an offer. I'll read just a couple of details on it, but I'll give everybody a moment to really read and think about it. So they said the location is remote, the expected salary is $50,000. they've given a job description and spoken about the duties and what the person is going to do. They've got requirements, and they have a little bit of a disclosure there. So with that, if everyone can answer the poll, we'll then talk a little bit about these two. Just gonna get ready to write down the results in case they disappear on us. So the first one is, what employment laws does this posting have to comply with? Ontario, BC, all of Canada, all of the world. Then in Ontario, what parts of this posting would violate the Employment Standards Act? Experience working with Canadian companies, no position type, and the salary, all of the above. I guess, sorry for the second one there, I'd probably mean no vacancy type. Sorry, I was late last night when I quickly pulled together the polls, so probably give everybody another minute there. I can't actually see how many people have answered, Natalie, so I'll leave it to you to determine when enough percentage is answered.
Yeah, all good. We're at about 60%, so we'll give them a couple more
Okay.
minutes.
Yeah, I'll give everyone a minute. Like I ran through this really, really quickly, but I wanted to make sure that we had time for the Q&A there.
All right, I'm gonna hit end poll on this and share the results.
Okay, so I picked the first question because I actually did think about only 10% of the people would really get the answer right. So in this scenario, it actually is all of the world. So as most places put these legislation, or requirements or guidance in place, they're usually pretty explicit that as long as the position is open to someone in their jurisdiction, the posting must comply. So I'm always advising, and I'm seeing it more and more in job postings, that people talk about where the employee can work from. And I have a lot of employers that are, they have a group of employees, say in Ontario, and then they have a remote workforce. You're responsible for wherever your employee goes, right? So similar to a job posting, if someone can apply, in BC, it's got to comply with BC. Right? So I always say, while you may say remote, if you're saying remote anywhere in Canada, you got to make sure the job posting is valid for every province and territory. Or you can say, this posting is open to candidates in Ontario and British Columbia, where we are prepared to hire. Right? And then that'll help absolve you from any potential implications there. And I kind of started to talk about it a little bit, so I guess I'll finish that thought. It's similar to with your remote employees in their contracts. You're going to want to say, this is a remote position within province Ontario. If you wish to, while this position is remote, if you wish to move anywhere else, you must speak to us and get approval first. And this is to make sure that you don't suddenly find out, like one of my clients, that they had all these Quebec employees because Ottawa is so close to Quebec. A bunch of them had moved over to Quebec. We then didn't have written offers in French, and it was this whole exercise of the client then going through understanding Quebec employment laws. What does termination look like in Quebec? How does that work in Quebec? What employment policies need to be in place in Quebec? Do they have to get into all of Quebec EI and other things there. So.
Oh, Justin, I think you're still on mute.
Sorry, folks. Yeah, still on mute. Yeah, so and then into the second one, really it was all of the above. In Ontario, you have to do a salary range. BC, for example, will let you say the posting should be $50,000, or $24 an hour. Yeah, and as well, it's missing the posting type there, right? Vacancy type, right? Whether it's a new or existing employee. And then experience working with Canadian companies, for an office assistant, it's really going to run up against the new rules in Ontario. And then I think it can move to the Q&A. I think that I was skimming through it, and there's one that I'll talk about really quickly, and that is in one of the slides when it talks about written offers and what you need to disclose to people in Ontario. That one really is for employers that are more than 25. The rest of it, it really isn't position specific. And I've talked a decent bit about BC, sorry. But there's a little bit of levels in there, but more on the reporting that you're going to be required to do to the government on salary disclosure and pay equity and things. They've instituted a whole host of reporting as well, and it's being phased in. I still think it's right now at above 100. This year it might shift down to 50. Right, so you're going to want to make sure that you're thinking about that. And 25 is really seems to be an Ontario number that we've picked for some reason with a few things, right? So there's a lot of grace in a lot of legislation in Ontario if you're less than 25 people there. So okay. Natalie, was there
Yep.
a separate Q&A or just the general?
The Q&A function in the chat is where most of the questions are, and then I've
Okay.
taken note of some in the chat. So I just
Okay.
mentioned if we don't get to them all, then you can answer them offline, and we can get the answers to these folks in a post-event email.
Yeah. Yeah, so the first one I'll answer is they're asking, are the salary ranges proposed or required in Ontario for 2026? So this is a requirement. It's fully enforced. The regulations are in place. January 1st, 2026 is when it goes live. And it's got to be up for them, right? So any hiring done after that, you're going to have to disclose the salaries. Someone is asking, how does equity compensation factor into the disclosure requirements? I hadn't really thought about this, which is interesting enough because I'm constantly helping my clients with stock option plans for their employees. You may want to speak to it in the position because it is really a great value add. I would ask yourself, how does the individual earn that compensation, right? So if it's a discretionary amount each year, or if it's an amount linked to a certain performance metric, then I think you'd have to ask yourself, is it really clear and how difficult it is to talk about the value of that compensation? Because the list that I was seeing in the regulations really is speaking about stuff that is hard values and easy to determine the value of, right? So incentive plans where, for every $100,000 you sell, you get $3,000. That's really easy to talk about in a position. Right, so that's a really a tricky one there, right? If you're at all a publicly traded company or anything, like that's very easy to find that value there. So that's probably something that had come out more later as courts kind of fill in the gaps in legislation. I would say though the easiest way is to try and comply the best you can, right? So if you've got an idea of the expected compensation value of those shares, I would really err on the side of sticking that in the posting. What if the Canadian experience is specific to an industry? Yeah, so I mean, the person is talking about Canadian pharmaceutical experience. Really the outs would be targeted at like a pharmacist, right? So if you're a pharmacy and a pharmacist there, like there is some outs there, and those outs tend to be more targeted though at the fact that you need a license to practice, right? So if you're really just selling to pharmaceutical companies, or something that's not really a pharmacist who needs a license, and you can talk about that, it's gonna be probably difficult to do that. No, nothing yet in Ontario about asking about someone's previous salary. There, right? I always caution, against that. Because you can get yourself a tiny bit into trouble there, right? But yeah, nothing yet in Ontario about previous salaries. Right? I only spoke about other provinces doing it because I'm kind of seeing that trend, right? So. Someone is asking, wonder if vacation entitlement per position is also part of transparency, like different benefit levels. As far as the posting requirements go, no, right? Like, and really benefits to that as well, right? That wasn't really part of the list, right? But I guess really with any posting, right, you're going to want to be as transparent as you can be, right? Vacation entitlement really is a driver for most people, so so really I didn't actually talk at all about the federal. So yeah, sorry, I should ask the question. Does this act apply to federally regulated businesses that operate in Ontario? No. So federally regulated businesses need to comply with the labor code that the federal government puts into place, right? So banks, airlines, you really, and you'd know better, but no, but I don't have any federally regulated employers, but I think I remember reading things about that being talked about. So I'm not sure if the federal government has done any similar acts there. Yeah, and I talked, BC is one province for sure that prohibits asking in any way, shape, or form about a previous salary. I think they're the first. PEI might now PEI also has it. And I think it's proposed as part of Newfoundland's upcoming legislation, and Nova Scotia, or maybe just one of the two, but it's in the proposed legislation in one of those two provinces. So someone is asking about more details about the no ghosting requirements. So, for example, is a screen considered an interview? If so, during the HR screen, do I let the candidate know that they'll hear back within a week if selected for the next steps? Is that sufficient? I'd say yes. It tends to be what I use when I do all of my interviewing for the firm. I tend to be kind of clear with candidates, right? We'll make every effort to let you know within a 2-week period, but really as I'm saying that out loud, no, you'd really want to, at the end of that 2-week period, you're going to have some written communication via email to them. So Right? So no, I'd say that really wouldn't be sufficient. The way the regulations are is you actually okay with it. So are there any changes to vacation time or pay? Not that I'm aware for vacation time or pay. Oh, actually, the one thing that we didn't speak about in on that front, and that was because it was from the year before, is putting in writing the employee if you're differing from the ESA in the way that their vacation pay is paid, and that agreement must be in writing. So most of the employment contracts I write, for example, say you agree that your vacation pay will be paid out in the ordinary course when you take vacation. That typically is most employees' preference, but actually the act says the opposite. So if I vacation, my vacation pay, which is really contrary to what most businesses are doing and really what most employees want. They're just happy for their salary to continue, but we've put into place a requirement that it needs to be in writing there. So that would really kind of also apply, I'd say, to any sort of use it or lose it policy, right? There. So someone's asking, what if we have no salary range but a set salary? I think that's a really good question. And I think it's something that the Ontario government has really thought of. BC has given you that flexibility to do so, but Ontario hasn't. They've really said, nope, it's got to be a salary range, right? So if you've got salary like bands, like I think some of some companies, they've got like steps or levels, because they're really formal with the requirements. Perhaps one way you meet the salary range is you talk about the fact that the steps for this position start at 50,000, and end, right? Or the band for this level. Really, I would think there, as long as you make best efforts to comply with the salary band requirements, a court is probably likely going to be friendly with you there, and we may actually see the regulations updated to say if you've got bands, then you should go with the band. I'd also say too, if this is coming because you're in a unionized environment, um, the Union Act that you've negotiated can really override parts of the ESA. I'd say get very specialized advice there. That's about the limit I know when it comes to labor and union law, is that really that contract can override parts of the ESA. And yeah, I'd say someone is asking, does the no ghosting apply only to those interviewed? Yes. So it's only those people that you've had like a phone call with or done anything with there. It doesn't apply to everyone who's applied for the position there. And I'm running through some of these because I've answered a few of them. So yeah, so I think there's definitely a few people asking, what if there really is no range for the position, right? Um, I think, it is potentially a way to create a range is if you're talking about an entry level position, and you're open to someone a little bit more senior, maybe you say, there's a salary band from, 50 to 100, but to receive 100, you really need at least X number of years of experience. That way you've done your best to comply with the range. Then someone's asking about what if we have a commission structure, right? So that would need to be disclosed, but there was no real requirement to get into the meat and bones of the commission structure, right? So, I could think of something where, the salary range is from $50,000 to $100,000. The last 25 really is really commission based and dependent on commission, right? So yeah, there's really no good guidance from the courts on what really needs to go in writing there. So I'm doing my best efforts based on history and what courts have said. So there. So someone's asking, what are the consequences if you accidentally ghost someone? Right? Yeah, sometimes the recruiting workload really is heavy. So really there, it's going to be up to the individual to report to the Ministry of Labor. Right? And as long as you have, things in writing, you're demonstrating you've got a plan and a program and a process, and someone just slips through the cracks, usually in that case, the ministry is just going to say, hey, in a month or 2 months, write us on your plan to prevent people from slipping through the cracks. They usually don't levy fines when you've really made best efforts to comply. It's when they come in and you're like, oh, well, yeah, I forgot to reply to this person, but you have no candidate tracking system, even if it's an Excel sheet. You really can't demonstrate that you've thought about ways and you've put in place processes and things to make sure you meet that 25 or 45-day window and make sure that you communicate with everyone. Really, like as long as you've complied in good faith, often the Ministry of Labor takes an education stance than a punishment stance. They come in again, then you might get a fine, yeah. And then, so I think I've gone through a lot of the ones in the Q&A. I'm just gonna skim through.
I think it's probably endless numbers of
Yeah,
questions
right.
that
So
everyone
yeah,
has for very good reasons. But maybe if you
yeah,
could take
right.
two
So
more, and then we can wrap up.
yeah, that sounds great. Yeah, so people are talking a little bit about remote work and the employee moving around, right? So yeah, really, you're responsible for the employment laws of where the employee sits, not where you sit yourself. And that was a big shock for a lot of my employers as they went really fully remote, especially here in the city of Ottawa, because half or a third of the city sits on the other side of the river in Quebec. Um, right? So I always say, do your best with policies and employment agreements to say, no, you've got to stay in your province. Let us know if you want to move out of it. Because it may be as simple as just updating your employment agreement to make it clear, your policies may fit the province that they're working in. Um, yeah, so someone is asking an important question about AI because it's notoriously opaque, right? So what you really want to consider when you're using these tools is what you're doing to demonstrate that you've vetted the tool and you've done work to make sure the tool complies, right? So a lot of my clients are adding AI or they're inventing AI models as part of their tools, right? And they, usually if you ask them, they can walk you through what they've done to make sure the AI is accurate and gives you good output, what safeguards they've put in place, right? And as long as you're doing a little bit of vendor due diligence, asking questions, a lot of these AI companies have trust centers, where they're putting up their policies and their documents. And as long as you've really can demonstrate you've done your due diligence, and like I said, probably given someone, an email address to say if you've got any questions or concerns that the AI may have filtered you out, pop an email here. I think you've tried to comply in good faith, so I think you'll be good there. So yeah, I think I'll hand it back to Kevin now. Thanks everybody. There were so many questions. So
Justin, do you mind if we sneak one more in? Daniel Craig
yeah,
has a really interesting one. He wrote, as a recruitment agency, are we obliged to follow up with candidates that have interviewed with our clients? Or is it that every candidate that they interact with for their clients? I think he was just trying to figure out as a service provider how far that they have to go to stay compliant.
Yeah. So really in that joint world, you're probably gonna want to be pretty, I would say from your side of things, if I was on your side of the fence, I'd say, hey, you're gonna need to have processes in place, so that there's open communication back and forth. Yes, I interviewed this person, this date, right? That way, you can demonstrate that you're keeping an eye on it. And then with your client, I'd say, hey, once we hand the individual over to you, you've got to notify them within 45 days of that last interaction, right? And that'll help if anything goes wrong. From a court's perspective, they may let the individual recover from either party, but then you might then be able to recover from that client to say, hey, we had to pay out because we had bigger pockets. But at the end of the day, we're going after you for that because in our contract, the liability sat on your side of the fence there. And you can demonstrate that you've taken steps to make sure that they complied with that, informed them, so really, that kind of is what turns in a lot of cases is that all of that documentation and evidence that you've complied in good faith and you've tried to comply with the legislation there. So
Awesome. Thanks a ton, Justin. So much of this is so complex and it changes so often. um, I really appreciate the time. Also, really appreciate everybody in the audience. There's probably at least half a dozen questions I've had asked that I'm very happy I was here and got to hear, because all these things are black boxes until we get to speak with employment lawyers. Also really awesome. I'm fairly certain everyone's pretty familiar with Employment Hero. Our mission is to make employment easier for everybody. So the more that we can do things like this and help people be better educated around compliance, the better it is for the community. And so we're really appreciative that people took the time out to join today. And Justin, thanks once again. We really appreciate your time.
yeah, thanks so much, Kevin. Thanks everybody. It was great to chat, and feel free to reach out. You've got LinkedIn there, how to contact myself and my firm.
Awesome. Thanks, everyone.
Thanks.